Hiibel v. 6th Judicial District Court of Nevada. Supreme Court, 2004. Justice Kennedy delivered the opinion of the court. The petitioner was arrested and convicted for refusing to identify himself during a stop allowed by Terry v. Ohio. He challenged his conviction under the 4th and 5th Amendments of the United States Constitution, applicable to the states through the 14th Amendment. 1. The Sheriff's Department in Humboldt County, Nevada, received an afternoon telephone call reporting an assault. The caller reported seeing a man assault a woman in a red and silver GMC truck on Grass Valley Road. Deputy Sheriff Lee Dove was dispatched to investigate. When the officer arrived at the scene, he found the truck parked on the side of the road. A man was standing by the truck, and a young woman was sitting inside it. The officer observed skid marks in the gravel behind the vehicle, leading him to believe that it had come to a sudden stop. The officer approached the man and explained that he was investigating a report of a fight. The man appeared to be intoxicated. The officer asked him if he had any identification on him, which we understand as a request to produce a driver's license or some other form of written identification. The man refused and asked why the officer wanted to see identification. The officer responded that he was conducting an investigation and needed to see some identification. The unidentified man became agitated and insisted that he had done nothing wrong. The officer explained that he wanted to find out who the man was and what he was doing there. After continued refusals to comply with the officer's request for identification, the man began to taunt the officer by placing his hands behind his back and telling the officer to arrest him and take him to jail. This routine kept up for several minutes. The officer asked him for identification 11 times and was refused each time. After warning the man that he would be arrested if he continued to refuse to comply, the officer placed him under arrest. We now know that the man arrested on Grass Valley Road is Larry Dudley Hiibel. Hiibel was charged with willfully resisting, delaying, or obstructing a public officer in discharging or attempting to discharge any legal duty of his office in violation of Nevada Revised Statute, Section 199.280. The government reasoned that Hiibel had obstructed the officer in carrying out his duties under Section 117.123, a Nevada statute that defines the legal rights and duties of a police officer in the context of an investigative stop. Section 171.123 provides, in relevant part, any police officer may detain any person whom the officer encounters under circumstances which reasonably indicate that the person is committing, or is about to commit a crime. The officer may detain the person pursuant to this section only to ascertain his identity and the suspicious circumstances surrounding his presence abroad. Any person so detained shall identify himself, but may not be compelled to answer any other inquiry of any police officer. Hiibel was tried in the Justice Court of Union Township. The court agreed that Hiibel's refusal to identify himself as required by Section 171.123 obstructed and delayed Dove as a public officer in attempting to discharge his duty in violation of Section 199.280. Hiibel was convicted and fined $250. 2. Nevada Revised Statute, Section 171.123.3 is an enactment sometimes referred to as a Stop and Identify statute. Stop and Identify statutes often combine elements of traditional vagrancy laws with provisions intended to regulate police behavior in the course of investigatory stops. The statutes vary from state to state, but all permit an officer to ask or require a suspect to disclose his identity. A few states modeled their statutes on the Uniform Arrest Act, a model code that permits an officer to stop a person reasonably suspected of committing a crime and demand of him his name, address, business abroad, and whither he is going. In some states, a suspect's refusal to identify himself is a misdemeanor offense or civil violation. In others, it is a factor to be considered in whether the suspect has violated loitering laws. In other states, a suspect may decline to identify himself without penalty. The present case begins where our prior case left off. Here, there is no question that the initial stop was based on reasonable suspicion, satisfying the Fourth Amendment requirements. Further, the petitioner has not alleged that this statute is unconstitutionally vague. The Nevada Supreme Court has interpreted the statute to require only that a suspect disclose his name. As we understand it, the statute does not require a suspect to give the officer a driver's license or any other document. Provided that the suspect either states his name or communicates it to the officer by other means, a choice we assume that the suspect may make, the statute is satisfied and no violation occurs. 3. Hiibel argues that his conviction cannot stand because the officer's conduct violated his Fourth Amendment rights. We disagree. Asking questions is an essential part of police investigation. In the ordinary course, a police officer is free to ask a person for identification without implicating the Fourth Amendment. Interrogation relating to one's identity or a request for identification by the police does not, by itself, constitute a Fourth Amendment seizure. Beginning with Terry v. Ohio, the court has recognized that a law enforcement officer's reasonable suspicion that a person may be involved in criminal activity permits the officer to stop the person for a brief time and take additional steps to investigate further. To ensure that the resulting seizure is constitutionally reasonable, a Terry stop must be limited. The officer's action must be justified at its inception and reasonably related in scope to the circumstances which justified the interference in the first place. For example, the seizure cannot continue for an excessive period of time or resemble a traditional arrest. Our decisions make clear that questions concerning a suspect identity are a routine and acceptable part of many Terry stops. Obtaining a suspect's name in the course of a Terry stop serves important government interests. Knowledge of identity may inform an officer that a suspect is wanted for another offense or has a record of violence or mental disorder. On the other hand, knowing identity may help clear a suspect and allow the police to concentrate their efforts elsewhere. Identity may prove particularly important in cases such as this, where the police are investigating what appears to be a domestic assault. Officers called to investigate domestic disputes need to know whom they are dealing with in order to assess the situation, the threat to their own safety, and possible danger to the potential victim. Although it is well established that an officer may ask a suspect to identify himself in the course of a Terry stop, it has been an open question whether the suspect can be arrested and prosecuted for refusal to answer. The principles of Terry permit a state to require a suspect to disclose his name in the course of a Terry stop. The reasonableness of a seizure under the Fourth Amendment is determined by balancing its intrusion on the individual's Fourth Amendment interests against its promotion of legitimate government interests. The Nevada statute satisfies that standard. The request for identity has an immediate relation to the purpose, rationale, and practical demands of a Terry stop. The threat of criminal sanction helps ensure that the request for identity does not become a legal nullity. On the other hand, the Nevada statute does not alter the nature of the stop itself. It does not change its duration or its location. A state law requiring a suspect to disclose his name in the course of a valid Terry stop is consistent with Fourth Amendment prohibitions against unreasonable searches and seizures. Petitioner argues that the Nevada statute circumvents the probable cause requirement, in effect allowing an officer to arrest a person for being suspicious. According to petitioner, this creates a risk of arbitrary police conduct that the Fourth Amendment does not permit. These are familiar concerns. Petitioner's concerns are met by the requirement that a Terry stop must be justified at its inception and reasonably related in scope to the circumstances which justified the initial stop. Under these principles, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop. It is clear in this case that the request for identification was reasonably related in scope to the circumstances which justified the stop. The officer's request was a common-sense inquiry, not an effort to obtain an arrest for failure to identify after a Terry stop yielded insufficient evidence. The stop, the request, and the state's requirement of a response did not contravene the guarantees of the Fourth Amendment. The court went on to reject the argument that requiring a person to identify him or herself in circumstances violates the Fifth Amendment privilege against self-incrimination.